Hello everyone, welcome to Public Law Session 4 with me, and today I will be looking at the topic of separation of powers. In order for us to do this, just a few guidelines to tell you what I will be doing. Now I will be looking at two questions on separation of powers, so I will be uploading it through two videos, part 1 and part 2. Okay, so the first video will be the most recent question, which is the 2019 question, which came up in last year's Zone B, 2019 Zone B question 3, which is on page 20 of your first handout. Okay, so the first question I'm doing is 2019 Zone B question 3, which is on page 20 of your first handout. Okay, so if you could just get that handout ready. Meanwhile, here we go. It's our mantra. There we are. I think I can. I think I can. I think I can. I know I can. Right? Okay. Off you go. Is everybody ready? I hope you are all keeping well. I wish I could tell you some jokes or walk around in class, but unfortunately we are all cooped up like prisoners, so we've got to do the best that we can. And if we think back in time, this is nothing compared to what our ancestors have done, going to fight in wars, right, and losing their lives outside in a war. We're just safely at home, so keep being safe and don't worry, things will get better. Okay, right. Without further ado, let's turn to page 20. Now the question says, discuss the extent to which the British Constitution has embraced means to adopt, all right, a rigid means tight, not flexible, all right? So discuss the extent to which the British Constitution has embraced a rigid doctrine of separation of powers. Discuss the extent to which the British Constitution has embraced a rigid doctrine of separation of powers. So you've underlined the most important words: extent, that means how much; embraced, that means adopted; rigid, that means a tight, inflexible doctrine. So suggested approach, introduction, number 1. So I've split up my answer into several parts. Number 1, introduction, responding to the question. In other words, is it true that the British Constitution has embraced a rigid doctrine of separation of powers? This answer will argue that that is not true. To a large extent, it has not embraced a rigid doctrine of separation of powers. And then number 2, what is separation of powers? Number 3, what are the objectives of separation of powers? Number 4, separation of powers and how it works in the core institutions of the UK. Number 5, rigid versions of SOP as compared to flexible versions. Number 6, the UK model, how does that work? Number 7, reforms in the UK model. Number 8, references to academic opinion. Number 9, judicial approach, and here I'm going to be focusing on particularly the Supreme Court in recent decisions, and there's also an update of a 2019 decision which appears in your exam updates, and I've included that on page 22, the Wilson case on the EU referendum, and then on page 23, conclusion, number 10. So that's structure that I'll be the structure that I'll be following. I now would ask you to go back, please, to page 20. So I've already told you, number 1, the response, what I would say is that to a large extent, the British Constitution has not embraced a rigid doctrine of SOP. This answer will argue that it has adopted a flexible method of SOP instead. Number 2, what is SOP? So it is about separation of powers, a distinction between the 3 things: the membership, the powers, and the functions. All right, so the membership means the personnel, membership or the personnel, the members, powers, and functions between the 3 organs of the state, and that would be the legislature, the executive, and the judiciary. And then explain also in number 2 when you talk about what is separation of powers, explain what these three institutions actually do. So Parliament enacts legislation, the executive implements the policy for that, and the judiciary is there to resolve legal disputes and to interpret statutes according to the will of Parliament. Okay. And then number 3, what are some of the constitutional objectives of separation of powers? Why do we want it? And I've put a couple of points there: to avoid centralization or abuse of power, all right? So that there is efficiency in the system, so that there is a preservation of liberty, so that there is an economic allocation of resources. Now, all these things, okay? So once you've put forward what the objectives of separation of powers are, then number 4, how does separation of powers work in the core institutions in the UK? So what are the respective functions, the roles and the personnel of Parliament, of the executive and the judiciary? Okay, so these are the different functions. So as I said just now, Parliament is involved with the enactment of legislation, statutes. The executive develops national policy, administration, foreign affairs, declaration of wars, and for example now with the COVID scare going on, it is the executive that develops the policies for that. So the Ministry of Health, for example, public health in England, is the one that is determining who gets masks, whether people will be tested. So these are policy decisions made by the executive, right? And then the judiciary, who will interpret statutes passed by Parliament, right? So once you've done that, then you come to number 5 and look at some of what we call the classic, or I've put the more rigid types of versions of separation of powers. So for example, the tripartite model put forward by Montesquieu, where there's a more of a rigid separation, more of what we call a total separation, as compared to constitutional writers like Tompkins in the UK, who look more for a dual bipolar system, all right, whereby instead of a three-legged stool, Tompkins pictures the situation in the UK sort of one leaning against the other. So the Crown and Parliament, leaning against each other, so to speak, in the UK. So the UK system is more of a flexible system in that sense, okay? And we'll come to the UK system in a minute, all right? Right, so what can we say about the UK system? I'm looking at point number 6 at the bottom of page 20. So you can mention and start off talking about the UK model by saying that there have been various reforms, and we'll come to the reforms in a short while. But for example, you may make reference to the Lord Chancellor's position, both pre and post the CRA of 2005. You can make reference to the Queen as the official head of all 3 of the branches, and how by convention she doesn't get involved with the day-to-day workings, of the 3 branches, and the use of constitutional conventions as safeguards in this overlapping system. Now, once you've done that, you can then go on to break it down to look at some of the overlaps. So for example, what are the overlaps between the organs? I'm going to start with firstly the legislature and the executive. Okay, so we're going to focus on the legislature and the executive first. That's at the bottom of page 20. So here you might want to focus on the something that the constitutional writer Bagehot emphasized in the 19th century, where he said that the overlap in terms of members between the executive and Parliament was something which he thought was actually a good thing. He described it as the efficient secret of the British Constitution. Now, why did Bagehot describe this as the efficient secret of the British Constitution? Because at that time, he was focusing on the communication level between these 2 departments. Today, I'm not sure whether that's a good thing, I don't think I would agree that it's an efficient secret, I would agree more with Lord Hailsham, the one of the ex-Lord Chancellor's descriptions of this overlap as being a dangerous thing, more like an elective dictatorship. All right, bottom of page 20. Yeah. So this overlap in terms of membership, how do we address that? What can we say about that? So to link it back to the question, you're basically telling the examiner that this overlap between the two shows that the British Constitution, the way in which SOP runs in it, is not rigid. There's a huge overlap in terms of members between the L and the E. Now, how do we deal with it? What's the checks and balance at the top of page 21? What are some of the dangers that occur when the executive dominates and manipulates Parliament like this? Well, one of the dangers is that legislation can get rushed, okay, and there may not be proper scrutiny mechanisms. So in order to address this, the checks and balance is the convention of ministerial responsibility. So the checks and balance is that ministers must be able to be questioned. They must be able to answer in Parliament for their policies, for what they've done, either what they've done or what they intend to do. So the convention of ministerial responsibility and accountability is very important because it acts as a scrutiny mechanism. All right? I'll come back in 1 minute. There's some noise outside. I'm going to just have to ask them to put it down now. Okay. Oh, all right. Is that better? I just had to go and there was some noise outside, so that might have interfered with the video. I'm sorry. I hope you're able to hear what I was saying. The last point I made was the overlap between the membership overlap between the L and the E. I said that ministerial responsibility is a form of checks and balance, but of course you know that ministerial responsibility itself is actually defective in the way that it runs, because though there are mechanisms to actually question ministers, like parliamentary select committees, for example, sometimes they don't work. Ministers can't be forced, they can't be compelled to attend these committee hearings. Sometimes they don't give the right answers. Sometimes they don't cooperate. Sometimes they don't answer questions in Parliament. The debates may not be effective. So, which means that ministerial responsibility as a method to deal with that overlap as a checks and balance is not adequate. All right. So why is this important for the question? Because we're saying that, well, there is this overlap. We have a checks and balance, but it's regulated by convention. It's not rigid. Ministerial responsibility is a convention. Okay. So that is the overlap in terms of function. Of course, you also have the checks and balance of the House of Commons Disqualification Act. All right. Which sets a maximum number of people to be members from the executive into Parliament. But that's about it. There are no other checks and balances. So in a sense, we can say that the scrutiny mechanisms are inadequate. Yeah. Now let's move on to overlaps in terms of function between the L and the E. Now, what are some of the overlaps in terms of function? The most important one is the lawmaking function. So it's Parliament's job to make law, to enact legislation. But the executive is sometimes asked to do that job. Am I right? So the executive is sometimes asked to do the job that Parliament is supposed to do. So here you have an overlap in terms of function. Now, what's the checks and balance? The checks and balance is that, well, there are two checks and balance. One is that this delegated legislation must go back to Parliament to be checked. Okay, it can't be amended. It must go back to Parliament to be checked. And some of the ways to do this is either through the positive affirmative technique or through the negative resolution procedure. So it basically either agreeing or saying no within a certain number of days, except that it's not often used in Parliament for many types of statutory instruments. So though we say that we may have parliamentary procedures to check delegated legislation, They may not be used that often. We also have methods whereby these delegated legislation can be questioned in court. It may be declared to be null and void by a court. Remember, courts cannot invalidate acts of parliament, but they can invalidate delegated legislation through judicial review. But then, how many cases are there where delegated legislation goes for judicial review? Not that many. So that means the scrutiny of delegated legislation itself is problematic, is inadequate. Okay. Again, this shows that the system in the UK is not a rigid system, as per the question. It's a flexible system, right? So we're done with the L and the E, and if you look at your page 21, we now go to number 2, the overlaps between the executive and the judiciary. Okay, the overlaps between the executive and the judiciary, the E and the J. So in terms of membership, there's no overlap here, because the House of Commons Disqualification Act of 1975 says that, well, if you're a judge, then you can't, stand for election in the House of Commons, all right, in Parliament. So there's no overlap in terms of membership. The overlap then is in terms of what? In what way do they cross each other's path? Well, you could talk about the whole process of judicial review, all right, and how this is the method whereby the judiciary scrutinizes the legality of the executive's decision-making process. All right, so the judiciary does not scrutinize the merits of a policy. Okay, so if it scrutinized the merits of a policy, then this would be a political thing. You understand? It would be a breach of SOP. They don't do that. What they do is to review the legality of a decision-making process. Okay, so the examples that I've given you are, for example, if you look at your page, what page is that? Page 21, right? When you look under number 2, the question that I've asked here is that when we look at the overlaps, okay, you've got judicial review, and we'll come back to judicial review in a minute, but does the executive sometimes actually perform the role of the judiciary? That means that could members of the executive sometimes be performing a judicial function, like, for example, sentencing? Now, the answer is yes. And this happened in the case of Anderson in 2002. In Anderson, if you look at the facts here, Section 29 of the Crime Sentences Act of 1997 allowed for the Home Secretary to basically have powers with judicial sentencing of life sentence, of prisoners with life sentences. So Anderson brought a case to say that, well, the Home Secretary is a member of the executive, of the cabinet. He should not be having a judicial function to interfere with my sentence. So he brought this case under the auspices of under the purview of the HRA. And you know that under Section 3 of the HRA, judges must interpret all legislation in light of convention rights. So the court here said that, well, Section 29 of the Crime Sentences Act of 1967 could not be read compatibly. Therefore, under Section 4 sub 2, they made a declaration of incompatibility to say that Section 29 of the Crime Sentences Act was incompatible with Article 6 of the ECHR, the right to a fair trial. So what we see here is, I spoke about judicial review, and the case of Anderson is an example of that. And we see here what I mentioned just now, how the judiciary looks at the legality of the decision-making process and says that, well, the Home Secretary is not making that decision in a lawful manner. It's against the right to a fair trial. So the HRA actually has ended up, in a sense, as a checks and balance mechanism, a powerful weapon in the hands of the judiciary in order to equip judges to come up with a DOI. Now, please remember, when judges make a DOI, the point that you have to make to the examiner is there's no breach of SOP here. Because when a DOI is made, yes, under Section 4, of the HRA, it does not affect the validity of that Crime Sentences Act of 1967, the continuing operation of it, or the enforceability of it. It continues to be operative until it is either amended, revoked, or Parliament decides to, just repeal it in some way. So that's important for you to talk about. And the whole process of judicial review, whereby the judiciary is actually looking at the legality of the decision-making process of the executive. So that is not a violation of SOP. That is sections 3 and 4 preserve SOP. All right. And then I've also asked the question there under E and J, what about the concept of justiciability? How far can judicial review go? And we know from the case of GCHQ that, well, they can only review something if the subject matter is justiciable. Okay? Justiciable is not defined rigidly. We'll come back to the concept of justiciability at the end of this answer when I look at Miller, both number 1 and number 2. But for now, suffice it to say that justiciability is a limit to judicial review. That means the court can only review if the subject matter is justiciable. Okay, and GCHQ told us that. Now we come to the third area that we're going to look at, which is the overlaps between Parliament and the judiciary, the L and the J. Okay, now first, any overlap in membership? No, because of the House of Commons Disqualification Act, you can't. Okay, so no overlap in membership. What about overlap in terms of function? Now, Parliament makes law, but do judges sometimes make law? The answer is yes. And we know that they did in the case of Crown NR on marital rape. All right. What's the checks and balance here? The checks and balance here is the convention itself that at the end of the day, the judiciary should know, that to maintain independence of the judiciary, they also need to take a step back. They cannot go too far. All right. And also the doctrine of judicial deference. In the event of national security, then they must give in to what the executive, the elected executive, and what they ask them to do. So there's a limit to what the judiciary can actually do. As far as national security is concerned, please look at the bottom of your page 21, where I've put there national security in italics, detaining foreign terrorist suspects. The case of A against SOS, the Belmarsh prison case, where the House of Lords had to look at section 23 of the ATC Terrorism, Crime and Security Act of 2011, and looking at whether section 23 could be read compatibly with Article 5 and 14 of the ECHR. And the Lord Bingham, the court, Lord Bingham, had to look at what is a public emergency threatening the life of the nation. Now, what did they say about that? What is a public emergency threatening the life of the nation? What did they say about that? Lord Bingham, the House of Lords, said that, well, we will accept what the Home Secretary says is a public emergency because he knows better. All right? He is the person who is equipped to deal with these kind of issues. It's a very political issue. So this brings us nicely to that line between, law and politics. Okay? So national security, political issue. But detention without trial, in this case, section 23, detention without trial for the foreign suspects, that's a legal issue. So political issue on one hand, legal issue on the other hand, right? Now, so they must be separated. But what if I do this and my two hands are like this? So they're actually mixed up, aren't they? So it's not that easy to separate the law and the politics, isn't it? Which is why, if you look at the bottom of page 21, when Lord Bingham talks about politics and law, sometimes it's not that easy to separate, and there's no rigid. How do you tie this back to your question? I put that link your discussion to the link your discussion of the above case to the question. So what does this case tell us? That is there a more rigid doctrine of separation of powers which is adhered to when there's an issue of national security? Will the courts defer to the will of the democratically elected executive? Now, the answer is yes, they will. And in the Belmarsh case itself, just like in GCHQ, the House of Lords said, what's a public emergency? We'll listen to what the executive say. But with regard to the indefinite detention without trial, now that is a legal issue, and we'll pull that bit out, and we are going to come up with a DOI. So that shows us that there is no rigid adherence to SOP, whether in the system, the constitution itself, or even in the judiciary itself. There must be a bit of flexibility. And we see this dilemma again, the law, politics, or the has it all joined together? And we see it again in Miller number 2, prorogation of parliament, which I'll come to later. All right? Okay. Now, and then once I'm done with those examples, I come to number 7. Have there been reforms in the UK model? I'll talk about the HRA again, right? Just now we mentioned it, and again, talking about the overlaps, talking about the, not the overlaps, not the word overlap now, what word am I? Interaction, the interaction between section 3, this is my section 3, this is my section 4, the interaction there, right? In cases like, if you look at the bottom of 21, in Ballinger, for example, and top of page 22, yeah? So in cases like Ballinger, what are we seeing here? What do we see? We see the Matrimonial Causes Act, section 11C, and how can we, the House of Lords had to read section 11C compatibly with the right to marry, article 12 in the ECHR. They couldn't do it, so they came out with the DOI. So the way in which section 3 and section 4 operate preserves SOP. All right, top of page 22. Another reform that you could talk about is the Constitutional Reform Act of 2005, and how that has played a very important role in modernizing and reforming the position and role of the Lord Chancellor, who is now, after 2005, no longer the head of the judiciary, no longer the Speaker in the House of Lords. He retains mostly his political role as a senior minister in the cabinet. All right, so the separation of the Lord Chancellor's role is much clearer now, and that shows us a big difference between those cases. I put there Stars and McGonnell, which shows what can happen when there is an overlap between the person who's involved in the judicial sphere and the legal or executive sphere, and that would be a violation of Article 6. All right. Another reform, of course, that you could talk about, which is a consequence of the CRA, is the creation of the new Supreme Court. So the removal of the law lords from Parliament, all right, which creates a better institutional separation. Yes, okay. And also, of course, the creation of the JAC, a better and more neutral appointment of the judicial system in the UK. So these are all illustrations to show how the UK system has evolved. There's no rigid separation, but there have been evolutions in the model itself to come up with ways to deal with these overlaps. All right. And then number 8, you might want to talk about, well, what about in the future? What are some examples or suggestions for reforms? Your textbook authors, Lesser, Sunkin and Merkins, suggest various ways to reform the system, to invigorate the Westminster system, to create opportunities for people to participate more directly in government decision making, embracing a more legal constitution, All right, these are all ways which have been put forward to reform the system. Lastly, before we finish, I would, or you could even have made reference to this earlier, right? When you, for example, when you were talking about the overlap between the L and the J, you could have brought up some of the recent cases of the Supreme Court. Okay, I've chosen to do it at the end simply because maybe I want to give I want to draw what I'm saying here to my conclusion in the end, to say that there is no rigid separation between law and politics. Okay, so and here under 9, that's why I am discussing the concept of justiciability. Okay, now I want to pause here to think about this. Yeah, now when I say the concept of justiciability, ask yourself what this means. Okay, so probably everybody knows what is, you know that, oh, if something is justiciable, the court can review. If something is not justiciable, the court can't review. Am I right? Okay, good. But what is the definition of justiciability? Now listen very carefully. We don't know. We have guidelines in GCHQ, but there is no rigid definition. Okay, now look at page 22. I've put there, look at the recent case law of the Supreme Court, and I've posed 2 questions. Question number 1, what is justiciable and what is not justiciable? Is there a clear demarcation? Demarcation means separation. The answer is no. Right? What is justiciable, what is not? We don't know. It's not clear. We don't have clear-cut rules set in rock, and the judiciary also don't want to do that because, first of all, they're not able to do that, and secondly, they also want some flexibility. So nobody wants to have a hard rock, iron cast, definition of what is justiciable and what is not. So we have a bit of gray, area here. Is that okay? Is that all right? You think about it. I've just told you that it is impossible in a sense and undesirable to rigidly define what is justiciable and what is not. Is there a clear demarcation? No. Now, look at the next question that I've posed for you to think about. Who decides what is justiciable? Who decides? Think about it. A case goes to court. So who decides whether it's justiciable? That court decides. So, and that court decides, which means that it's a little bit, it's a very subjective thing, isn't it? It's like, for example, if somebody asks you, is COVID-19 a political thing, a political issue, or is it just about health? If we change the question to, well, if a COVID vaccine is developed, should everybody have equal access to it? The minute you talk about equality, it becomes a legal issue as well. Everybody has a right. Let's say the vaccine is developed in China and I'm sitting here with you in Malaysia. Do we also have a right, a common right of humanity to that vaccine? I'm sure the vaccine will come, pretty soon, right? Humans are, the human being's capacity is immense. Our brain capacity is immense. It's just a matter of time that a vaccine will be developed. So is that a scientific issue? Is it a legal issue? Is it a political issue? Is it a Malaysian issue, a Chinese issue? Look at President Trump calling it a Chinese virus. Does it make sense to you? Right? Or is it a human issue, a global issue? Now, I have no answers for these questions that I'm asking you. I'm merely posing to you that sometimes there are no rigid demarcations. And the best way to illustrate this to the examiner is to look at the 2 Miller decisions. Now, look at page 22. So what do I want to say about Miller number 1? The enforcement of the Sewell Convention. Now, the Sewell Convention has been codified. It's now section 2 of the Scotland Act of 2016. And section 2 of the Scotland Act of 2016 amends section 28 to create a new section 28 sub 8 of the Scotland Act of 1998. So it's law in that sense, isn't it? But yet it was not enforced. all 11 judges unanimously in Miller number 1 said that it's a political issue. It's not a justiciable issue. They're not going to enforce it. Am I right? So it's in the Scotland Act, it's law, but it's a political convention and it can't be enforced. That is evidence to me to show that separation of powers and indeed the whole issue of justiciability is a fluid concept. It depends whether something is justiciable, depends who you ask. But anyway, for what it's worth, Miller number 1 was a unanimous decision. All 11 said that it's not justiciable. The Sewell Convention is political. They're not going to enforce it. Done. Then comes Miller number 2 recently. The decision was in September last year. All right, so what's that? Just about 6 months ago. Very recent decision. And there, what was the subject matter? It's a prerogative power, which is a very political prerogative power, right? Prorogation of Parliament. That means stopping Parliament from operating. That's the right of the Prime Minister. It's never been challenged before, right? It's normally never challenged. But listen, we are not living in normal times, all right? So before well, in October, when they were in September rather, when they were thinking earlier that they were going to exit the EU at the end of October. You remember the date was set for 31st October 2019, right? And then Boris Johnson went and prorogued Parliament. Everybody was upset. A lot of people were upset, isn't it? Because the opposition were very upset. The people were upset. Now, why were they upset? Because there's no chance to talk about how are we going to deal with this. Correct or not? It's a crisis. How do you deal with it? When there's a crisis, people want to, people want to expect our elected members of Parliament to help us to get through that crisis. That's what they're there for. Right? So that's why Lady Hale said in this case, it's a one-off case. Now, when the Supreme Court was asked to look whether is this a justiciable matter, it's very important for you to understand the Supreme Court said yes, it's justiciable. Now, what is justiciable? The exercise of the Prime Minister's prerogative power of prorogation of Parliament. So Lady Hale said it is justiciable. Please notice that this is in direct contrast to what the High Court said. The High Court said it's too political, it's up to the Prime Minister, it's not justiciable. Right? It never went to the Court of Appeal because it's of such supreme importance, it jumped straight up to the Supreme Court. Supreme Court says it is a justiciable matter. And I've got the Supreme Court press summary here. I emphasize to you all, how important this case is. On page, oh gosh, I've got to speed up. It's already 38 minutes. On page 1, right? 5 lines down. This is the press summary, right? If you don't have it, it's okay. The Lady Hale says that this is looking at the legality of prorogation of Parliament, okay? And it is in the first paragraph, the question arises in circumstances which have never arisen before and are unlikely to arise again. It's a one-off. A bit like the COVID-19. Well, I hope so anyway. I hope it's a one-off, right? I hope we don't have another kind of pandemic like this. So in other words, what she's saying, it's exceptional. It's something that we've not encountered before. It's not something that's going to happen again, right? But on page 2, she looked at the first question is whether the lawfulness of the Prime Minister's advice to Her Majesty is justiciable. The court holds it is. Now, why? Because the court has concluded that the case is what? Yeah, okay, it's about politics, but it's about what? It's not just about politics, it's about power. It's about the limits of the power to advise the Queen to prorogue Parliament. So it becomes a legal issue as well. You see that? Politics, proroguing Parliament. The extent of that power, it becomes a legal issue as well. You understand? it becomes a legal issue as well. So therefore, the Supreme Court said, we can, and we will look at it. And having looked at it, what we see is there's no justification for proroguing Parliament like this. It has interfered with two fundamental principles of our Constitution. What are the two fundamental principles? Parliamentary supremacy and parliamentary accountability. It has hindered Parliament doing what it's supposed to do. It's unlawful. This prorogation is unlawful. That was the decision. It's an extraordinary decision. All right? And it shows us how. I mean, you know, this decision is a beautiful decision for you to use to show it is not a rigid SOP. And the concept of justiciability itself is like clay. It's a malleable concept. All right? So if you look at the bottom of page 22, I've asked some questions here. In Miller number 2, was the prorogation of Parliament a legal or political issue? My answer just now was what? Was what? Legal or political? What did I say? It's both. It's both. All right? Where do you draw the line? And what did Lady Hale say about the issue of SOP in the legal process? What did she say? What did she say? Now, if you turn to page 23 and look at the conclusion, I'm going ahead in a sense. Look what she said in the conclusion. All right? Turn to page 23, right at the end. I've extracted a quotation, a beautiful quotation, which you can use in many answers in the exam. Although the courts cannot decide political questions, the fact that a legal dispute arises from a political controversy has never been sufficient reason for the courts to refuse to consider it. Many, if not most, of the constitutional cases in our legal history have been concerned with politics in that sense. You see? All right? So there's no rigidity, class. All right? Now, please go back to page 22. Right? So I've also asked another question. What about the Convention of Parliamentary Accountability through collective ministerial responsibility? That's a convention, right? And the courts don't enforce conventions, right? Because they are political matters, right? They are political rules, right? Now listen. In the video on conventions, I explored this and I came to the conclusion that what? In my opinion, Lady Hale is indirectly enforcing the Convention of Parliamentary Accountability. She's saying that, look, you know, you guys get into Parliament, do your job, you know, answer questions. It's important. It's a basic, fundamental principle of the Constitution. So in a sense, is she enforcing something political? Yes, she is. Yes, she is. All right? But she's defending that by saying that it's essential to the running of the Constitution. So again, she says it's a principle, a fundamental principle of the British Constitution. A fundamental principle of the British Constitution, therefore it can be invoked. So you see here, you know, it's not a rigid kind of concept of justiciability. It's a malleable, moldable concept, and you really ought to bring this into your answers. All right, don't oversimplify something. Okay, it's all right to have a bit of murkiness because life is not all clear water. You're bound to get a bit of murky sometimes, and that's realistic. It's okay. All right. Okay. Now, and then bottom of page 12, I've also put the recent update of the case of Wilson, whereby you see that with some areas the courts have said, look, some things we're not touching. One thing that we're not touching is if you come and tell us or bring a case and say that, hey, that referendum was not held properly, whoops, we're not touching that. That's too political. Two very good examples of that. One is a very recent case, Wilson, just recently decided a couple of months ago. And if you look at the bottom of page 22, that's an important update. I've put there, what does the Wilson case establish on SOP? The Wilson case was brought because the claimant basically argued that there had been irregularities in relation to the referendum, the EU referendum. Okay, but the court said, look here, whether there were irregularities or not in the referendum, those are technicalities. It's a political issue. You don't come and ask us to rule on that. It's not justiciable. Very clearly they said. So yeah, clear, law, politics, clear, there's no this here, clear. All right, so here we see a strong endorsement of separation of powers here, where bottom of page 22, the court says, approved a judicial observation on the separation of powers and said, put bluntly, the debate which the claimant seeks to promote, that's a nice quote for you to bring into your answer, belongs firmly in the political arena, not the courts. And of course, the Wilson case, if you turn to your page 23, follows the earlier approach of Wheeler way back in 2008, where in Wheeler also he was contesting and saying that, the government promised they'll have a referendum on an issue they didn't have. I'm running to court to contest that. And the court said, please go back home. Yeah, because that's a political issue and we're not getting involved. And if you look there, the second paragraph on page 23, where the court said that, look, whether or not the Lisbon Treaty was signed, that's a political perspective, a political judgment. Moreover, the subject matter, nature and context of whether the government made this promise, whether the government didn't make this promise, these are all political issues. We're not going to get involved with that. Okay. So conclusion. So at the end of the day, to what extent has the British Constitution embraced a rigid doctrine of SOP? As the answer clearly has established, it doesn't. It's not a rigid doctrine. It's a flexible doctrine. Just like the concept of justiciability is flexible, malleable. And I leave you with that quotation by Lady Hale in Miller number 2. Although the courts, and if it was me sitting the exam, I'll memorize this quotation, although the courts cannot decide political questions, the fact that a legal dispute arises from a political controversy has never been reason for the courts to refuse to consider it. Many of, if not most of the constitutional cases in our legal history have been concerned with politics in that sense. That beautifully tells us that the line between law and politics, right, that line is a thin one, it's difficult to draw, it's malleable, it's flexible, its meaning, its scope, its application is something in the hands of the court itself. And if they need to use that concept in a manner that illustrates judicial activism, they will do so. And both the Miller decisions are reflective of this to me. All right? That brings us nicely to the end of this question. I'd like to thank you. I hope you are still with me, listening to this video. I wish you the best of luck in your exams. And I will post another answer to another SOP question in the next video, which will be video number 5. Thank you. Bye-bye for now.